After studying this module, you shall be able to know about the legal environment in India, learn about the changes in legal environment that have occurred so far, and identify the changes and their impact on business environment, and correlate the legal environment and business environment together. The legal dimensions mean rules and regulations which are framed for regulating the business. In every country, laws are framed to protect the interests of citizens, to provide safety and health at work, to preserve the environment and to channelize the routes of investments. The laws of any country are framed by the government that affects the business environment also. Laws of a country are like flipped coin because it may increase or curtail the business opportunities. For instance, provision of subsidies to small-scale industries helps them to compete with large-scale industries, and on the other hand, special reservation for SSIs will decrease opportunities for new entrants. Therefore, it is imperative for business to work under the limits of a legal environment of a country. Legal environment creates a boundary beyond which business cannot go. But legal environment of any country is not static. It keeps on changing according to the requirements of the business, keeping in view the welfare of its citizens. This chapter deals with the changes in the dimensions of legal environment in India. Legal environment in a country has an important role in the decision making of an organization. An organization is required to have full knowledge about the laws of the country, as unawareness is never an excuse. Non-abidance of any law may result in heavy fines, penalties, and prosecution and punishments. Therefore, an organization is required to follow all the rules and regulations created by legal environment. We shall now discuss the legal environment in India. In India, study of legal environment can be divided into two following periods: the pre-independence period and the post-independence period. Let us first learn about pre-independence period. This period was essentially marked by drain of wealth. Indian Contract Act 1872 was passed. The act was formed to promote and regulate the business, as this act clarifies formation of contract and consequences of breach of contract. Now let us discuss the post-independence period. India was marching towards economic development after 1947. Different acts were formed to regulate different sectors of the economy. Pre-independence of legal environment. Let us understand the Indian Contract Act 1872. Before independence in the British period, Indian Contract Act 1872 was passed to promote and regulate business activities. The Indian Contract Act includes all the provisions related to the formation of contract, breach of contract, and consequences of breach of contract. In the pre-independence era, Indian contract was introduced to clearly define the relationship between two parties entering into a contract. The Negotiable Instrument Act. In this era, the Negotiable Instrument Act 1881 was also introduced. In India, it was believed that instruments were used in early times also. Initially, the word hundi was used to represent The instruments of exchange. The word was derived from the Sanskrit word hund, which means to collect. Due to the existence of British rule, commercial activities were continuously increasing, and therefore it was realized that only coins were not serving the purpose. Therefore, credit instruments were introduced to perform the function of money. The Sales of Goods Act. In the Chapter 7 of Indian Contract Act 1872, the concept of sale of goods and movable were contained. But the time need for a separate act related to rules and regulations for sale of goods was realized. Therefore, Sale of Goods Act was introduced in the year 1872. The Sale of Goods Act defines the rules, penalties, and regulations related to sale of goods and movables. The Act came into force on 1st July 1930 and extends to whole of India except Jammu and Kashmir. Let us now discuss the Partnership Act 1932. The Partnership Act 1932 came into force on 1st of October 1932. Initially, this act was also a part of the Indian Contract Act, but later it became an independent act in 1932. The Partnership Act is a central act but also is administered by state governments. The act is applicable to whole of India except Jammu and Kashmir. As per Section 4 of the Indian Partnership Act 1932, partnership is the relation between persons who have agreed to share the profits of a business carried on by any one of them acting for all. Under partnership law, a partnership firm is not a legal entity, but only consists of individual partners for the time being. It is not a distinct legal entity apart from the member partners constituting it. The Payment of Wages Act. There was a time when problems related to payment of wages to employees were not being paid, or wages were not uniform, or were not paid regularly. With the growth of industries, it was realized that problems related to wages were also increasing. Then industrial workers started rising against their exploitation, and problems of strike, lockouts also started. In the year 1926, Government of India intervened in this matter, and as a result, a commission was formed to investigate the matter. The commission presented the report in 1933 and introduced the payment of wage bill in Legislative Assembly. In September 1935, finally the Payment of Wages Act was passed. Post-independence legal environment. After independence, it was felt that for the smooth functioning of business sector of any country, not only one but different acts were required according to different areas affecting business environment of a country. Keeping in view this fact into consideration, following acts were introduced to create an efficient, transparent, and working business environment. First, we will discuss the Industrial Development and Regulation Act, which is meant to control industrial sector. For the regulation of industrial sector, IDRA, Industrial Development and Regulation Act was formed. The aim of the Act was to control the direction and efficient utilization of scarce resources of the country. It was essential to form an Act which will help in the imposition of effective system of justice to regulate commerce and trade. Now let us talk about the Companies Act 1956, which was meant to regulate working of companies. The Companies Act was introduced in 1956 with an objective to administer the working of companies. Companies Act empowers the central government with certain powers to regulate the functioning of companies. The Companies Act is administered by the central government through the Ministry of Corporate Affairs. This Act contains provisions relating to formation, financing, functioning, and winding up of the companies. The Act aims to companies to check if any unfair practice is being followed by companies and to direct their activities in the direction of public interest. If at any time it has been proved that company is involved in any fraud or cheating, then under the provisions of the Companies Act 1956, penalties and punishments can be imposed on the company. Let us now talk about the labor laws, which is meant to protect the interest of the employees. Under this, first we will talk about the Industrial Dispute Act 1947. The Industrial Dispute Act was introduced in 1947 to create industrial harmony. The objective of Act was to ensure justice to both employers and employees. The Act also explains provisions relating to contingencies as to a strike, lockout, when these can be declared illegal, conditions related to retrenchment, layoff, and discharge and dismiss of a workman. The Act gives details, explanations on different matters related to employer and employees of the industries. Now let us talk about the Factories Act 1948. The Factories Act was introduced in 1948 with the aim to regulate the working conditions of employees in factories in order to provide them safety, equal treatment, and also enact certain special provisions relating to women and children. The Act contains provisions related to working hours, issues relating to health, safety, and welfare of employees, and also explains penalties in case of non-obedience of provisions relating to this Act. Now we will talk about the Minimum Wages Act 1948. The Minimum Wages Act was introduced with an objective to secure social justice and economic justice among employees. This Act was aimed to avoid exploitation of employees. Under Minimum Wages Act, it is an obligation for employers not to pay below the prescribed minimum wage to employees. This Act ensured that employees are getting at least a minimum wages, which in turn leads to equitable distribution of national income and economic development. If at any time need is felt, then minimum wage rate can be revised by the central and state governments. Provisions relating to payment related to wages, etc., are also defined in the Act. Now we will talk about the Workmen Compensation Act. The Workmen Compensation Act was formed to provide some monetary relief to employees who met with some accidents during working hours causing either death or disablement of employee. As per Workmen Compensation Act, every employee who is engaged for the purpose of employer's business and who suffers an injury in any accident arising out of or in the course of his employment is entitled to receive compensation. Now let us discuss the Employees State Insurance Act. The Employees State Insurance Act came into force in 1948 in order to provide social protection to workers and their dependents. In contingencies, for example, maternity, sickness, and death, or any physical disability due to an injury caused during working hours, the Employees State Insurance Act is applied to following two categories. Number 1, non-seasonal factories using power and employing 10 or more persons, and 2, non-seasonal and non-power using factories and establishments employing 20 or more persons. The central and state governments are empowered to extend provisions of the Act to various classes such as industries, commercial undertakings, or others. Employees covered under the ESI schemes are entitled to receive medical facilities for self and dependents. Women also get maternity benefits, and in case of death of an insured person during working hours, dependents of that person are entitled to receive pension. Let us now discuss the MRTP Act. This was meant for the control of restrictive trade practices. The Monopolies and Restrictive Trade Practices Act was introduced in the year 1969 to ensure that any business operation in the country is not leading to concentration of economic power in few hands and creating monopoly in the market. The Act was applicable into whole of India except Jammu and Kashmir. This Act aimed to control monopolies and prohibit monopolies and restrictive trade practices. Let us now talk about Securities and Exchange Board of India, that is popularly known as SEBI, which is meant to regulate capital. Securities and Exchange Board of India was set up in the year 1988 as non-statutory body, but later on it came into existence as an autonomous body in the year 1992. SEBI is also known as a watchdog of Indian capital market and aims to make India one of the best security markets in India. SEBI was formed to define responsibilities of capital and money market and to regulate working of capital market. Functions of SEBI can be divided into three categories, that are legislative, judicial, and executive. As per legislative requirements, SEBI is required to draft rules, conduct inquiries. According to executive function, SEBI can pass the rules and has the power to order in its judicial capacity. The broad objective of SEBI can be as follows: to protect the interest of investors, to promote development of securities market, to handle grievances of investors, to promote efficient services by brokers and other intermediaries, and to ensure fair trade practices by the issuer of securities. Let us now talk about the Consumer Protection Act 1986. Consumer has a very important place in the market. Whole market revolves around the consumer, as only those goods are produced by producer that satisfy the needs, taste, and preferences of consumers. Though consumer is considered as the king of the market, still consumer is one who normally gets exploited by businessmen in different forms such as high price of commodity, low quality, etc. The reason behind exploitation was unawareness of the consumer and their scattered population. With the passage of time, a need for well-informed and well-organized consumers was felt to stand against sellers in the market. Therefore, to protect the interest of consumers from the unscrupulous and to businessmen and to create a platform where consumer can register their grievances, Consumer Protection Act was introduced. In 1986, the Consumer Protection Act was passed and is applicable to whole of India except Jammu and Kashmir. The Act was introduced to protect the interest of consumers, and the consumer councils were established to hear the complaints of consumer. Under this Act, 3 redressal agencies have been established, namely the District Forum, the State Commission, and the National Commission. The basic objective of redressal agencies is to address grievances of consumer related to different amounts. Now we will discuss about taxation laws. This is to have transparent tax structure in India. First we will talk about the Wealth Tax Act 1957. The Wealth Tax Act has also been recently abolished. The Wealth Tax Act was implemented in the year 1957. It is applicable on every individual, Hindu undivided family and company. The wealth tax is administered by the Income Tax Department. As per this Act, 1% tax was applicable on wealth exceeding 15 lakhs initially, which was raised to 30 lakhs subsequently. In 1993, some specified assets such as motors, cars, jewelry, residential buildings, yachts, etc. were included under the wealth tax. Assets like shares, bonds, bank deposits and mutual funds, etc. were not part of Wealth Tax Act as they were outside the definition of wealth. Now we will discuss the Foreign Exchange Regulation Act, which was meant to control the foreign exchange market. Foreign Exchange Regulation Act was passed in the year 1947, and the final structure of the Act came into existence on 1st January 1974. The Act was introduced to conserve foreign exchange reserves of India and to use foreign exchange reserves judiciously. FERA was implemented to regulate and control payments in foreign exchange. The Act regulated all dealings in foreign exchange, directly or indirectly affecting the amount of foreign exchange reserves, regulate import and export to control foreign exchange, and also to promote efficient utilization of foreign exchange to accelerate economic development of the country. This Act has also been abolished. Let us now discuss the changes and amendments in the Act. The amendments in the Acts were introduced as follows. Amendments in Companies Act 1956. Different amendments in the Companies Act were introduced in the year 1960, 1968, 1970, 1977, 1993 and 1997. Some of the important amendments are listed below. Let us discuss the amendments passed in the year 1977. Central government was authorized to grant exemption to companies from the operation of Section 58A, which otherwise restricted companies to accept deposits from public. It empowered companies to donate up to 5,000 for employees' welfare purposes, and empowered CLB, that is Company Law Board, to enforce its order like court of law. Now let us discuss the amendments of 1997. It permits the company to raise money through new instruments. A person could be director of 15 instead of 20 companies. CLB was replaced by Company Law Tribunal. It provided penalties and punishments for contravention of provisions for better compliance. It simplified provisions of winding up of companies. And companies were empowered to purchase their own shares. Amendments in SEBI. Following amendments have been introduced in SEBI Act across different years. Let us discuss the amendments in Securities Exchange Board of India in the year 1995. SEBI was empowered with regulatory power over corporates in the matter of securities and other related matters. In the year 1999, derivatives and other instruments of collective investment schemes were included under the definition of securities, and RBI was enabled to regulate the transactions in government securities and other related instruments specified by the government. In the year 2002, Serious Fraud Office (SFO) was formed to provide more power to punish all the offenders. SFO can exercise its powers through search and seize books, register and documents of intermediaries of any other persons associated with the securities market. Fine of 25 crores was imposed as penalty for inside trading. Maximum number of board members increased from 6 to 9. Let us now discuss the amendments in the year 2013. The amendment widened the area for eligible candidates for the post of presiding officers at the Securities Appellate Tribunal, that is SAT. The bill also extended the eligibility criteria for SAT presiding officers' role and included sitting or retired judges of High Court with a minimum service of 7 years. Let us now discuss the amendment passed in the year 2014. It was rationalization of penalties. Special court for offense was established. India has seen a lot of changes in the legal environment in the last 6 decades. It is necessary for business to understand that any change in the legal environment may affect business positively or negatively. Business should always be prepared to face the challenges and utilize the opportunities created by the changes in dimensions of legal environment. Changes in any law may increase in available opportunities. Therefore, business firms should analyze the environment and use it for the better developed and prosper business. On the other hand, some changes in legal environment may hamper the growth of business also. It is beneficial for every firm to be aware in advance about the possible changes in legal environment, analyze its impact on business, and also be prepared with strategy to face the same. If any firm fails to do so, the same and is not able to respond to the changes, then in the long run businesses may face downfall. The legal environment of all countries is always dynamic, and as the government has to amend the rules and regulations from time to time according to changes that may have occurred in the national and international scenario. We shall now recapitulate what we have learned so far. The legal dimensions mean rules and regulations which are framed for regulating the business. In every country, laws are framed to protect the interests of citizens, to provide safety and health at work, to preserve the environment, and to channelize the routes of investments. Legal environment of any country is not static and keeps on changing according to the requirements of business, keeping in view the welfare of its citizens. An organization is required to have full knowledge about the laws of the country, as unawareness is never an excuse. Non-abidance of any law may result in heavy fines, penalties, prosecutions, and punishments. Study of Indian legal environment can be done by dividing it into 2 periods, namely the pre-independence period and the post-independence period. In the pre-independence period, the acts such as Indian Contract Act, the Negotiable Instruments Act, the Sale of Goods Act, the Indian Partnership Act, and the Payment of Wages Act were passed. In the post-independence period, acts such as the Industrial Development and Regulation Act, the Companies Act 1956, the Wealth Tax Act, the Industrial Disputes Act, the Factories Act, the Employees State Insurance Act, the Minimum Wages Act, the SEBI, the Consumer Protection Act, Foreign Exchange Regulation Act and MRTP were also implemented. From time to time, different amendments were introduced to make legal environment more effective and efficient. Therefore, Companies Act 1956 was replaced with Companies Act 2011. MRTP was replaced with Competition Act and FEMA was introduced in place of FERA. India has seen a lot of changes in the legal environment in the last 6 decades. It is necessary for business to understand that any change in the legal environment may affect business positively or negatively. It is advisable for every firm or company to be aware in advance about the possible changes in legal environment, analyze its impact on business and also be prepared with the strategy to face the same. If any firm fails to do so, the same and is not able to respond to the changes, then in the long run, the business may face downfall. The legal environment of all countries is always dynamic, and as the government has to amend the rules and regulations from time to time to suit the needs and according to changes that may have occurred in the national and international scenario.